afternoon, Dr. Ambi. It has become an historical fact that women are not always equal to men. Well, we can see that equality between men and women inside the marriage institution constitute one of the most pressing gender issues recently. The biggest aim is to be prioritized to enable Malaysian law to protect wives from getting raped by their husband. Based on the book, The Histories of the Players of the Crown, Sir Matthew Hawke declared that husband cannot be convicted of rape against their wife, since the wife has given her consent to her husband by entering into a marriage, and this consent cannot be revoked. We disagree with this fact. The wife should still have the authority to choose whether she consented to sexual intercourse or not. Just because there is marriage, it does not make rape legal. A 2014 University Science Malaysia study estimated 9% of ever partnered women in Peninsular Malaysia have experienced domestic violence in their lifetime. Of these 9%, 11% reported forced sex as a form of abuse. This suggests around 100,000 women in Malaysia have been raped by their intimate partner during their lifetime. NGO data shows that sexual abuse is a common form of domestic violence. A third of domestic violence survivors who sought refuge at Women's Aid Organization in 2017 experienced sexual abuse. Therefore, what we can see is our intention will be directed towards removing husband's immunity to rape wife by discussing on the topic of marital rape in Malaysia, and it shall be codified as well as a comparison to England law.
But how reliable are the statistics? These are, as you mentioned, 2014 and 2017 statistics. Maybe in 2023, the statistics of marital, so-called marital rape is non-existent.
Well, by right, if there is a statistic, it either become more or it become less. Even if it becomes more and less, we should solve this issue also, in order to prevent it to become more in the future. Well, looking into it, starting from the definition of rape, based on the section 375 of our penal code, it is when he intentionally penetrates the vagina, anus, or mouth of another person with his penis without that person's consent. However, this only applies to a man with a woman other than his wife, and in Malaysia, it is not possible for a husband, to rape his own wife. Well, marital rape places the offense as having sexual intercourse by the husband against his wife without her express consent. The husband and wife must be legally married and recognized as a married couple. Thank you.
Thank you for the detailed introduction, Sunil. Moving forward, let's begin with the elements of rape required under the Malaysian jurisdiction. Section 375 of the Penal Code states, a man is said to commit rape is who has sexual intercourse with a woman under circumstances falling under any of the following descriptions. First, if it is against the woman's will, without her consent, due to the misconception of fright, due to her mistaken belief, or without her capability of understanding the act, or if she is underage, whether with her consent or not. Now, I'm going to talk about, in regards to marital rape, the exception under section 375 of the Penal Code states that sexual intercourse by a man with his own wife by marriage, which is valid under any written law for the time being in force, or is recognized in Malaysia as valid, is not rape. Does this mean that women are property of men once they are married? Furthermore, is it deemed to have consent once she marries him? These questions are worth considering, and we will give more detailed discussion later. However, there are two exceptions to this section. Firstly, a woman living separately from her husband under a decree of judicial separation, or a decree nisi not made absolute. Second is who has obtained an injunction restraining her husband from having sexual intercourse with her. That is all. Thank you.
Now, let us talk about more details when it comes to marital rape in Malaysia itself, and our beloved country Malaysia, where I hold my passport from. Now, whether it be under civil or Sharia law, marital rape has not, in the broadened sense, been a crime or subject to punishment. However, Section 375A of the Penal Code punishes a husband who solicits sex by intimidating or injuring his wife. As stated in this section, any man who causes bodily harm, fear of death to his wife or any other person to force sexual relations to his wife shall be punished with imprisonment. We shall now move on to saying, regrettably, Section 375A does not mention the most important part of the elements needed to prove rape, which is consent. Which means that consent plays no role in delegitimizing intercourse. We are basically saying that the contract of matrimony presumes that a married woman has consumed to marital intercourse. And the consent cannot be revoked because marriage is permanent. Irrevocable consent, on the other hand, should not be utilized to strip a woman of her bodily autonomy. Although Section 375A seems to cover marital rape, with unfortunate scrutiny, the husband is punished not for having sexual intercourse with his wife, but for causing hurt, fear of death, in order to have sexual intercourse. Rape seems to be a non-issue in this provision, as all it did was create a specific offense, a sort of criminal intimidation by a husband to the wife in order to have sexual intercourse. And as mentioned earlier, the exception to 375, Section 375A seems to be a compromise provision to marital rape. Now, those statistics mentioned earlier in the introduction are quite unfortunate, how those wives had to experience those traumatic events. Marital rape can, due to its inherent characteristics, inflict a distinct and severe harm on its victims, primarily because of, or rather in spite of, the connection between the victim and the perpetrator. It is posited that this connection is founded on trust and in confidence, and the violation of this trust should be regarded with heightened seriousness. Essentially, the contention is that because of this trust within the relationship, marital rape can become an even more egregious offense, akin to the broader issue of domestic violence, of course. Consequently, safeguarding and codifying law regarding marital rape can be seen as an extension of persevering the integrity of the family unit. The impact of marital rape on the wife has serious consequences, as stated earlier, and by reference in the working paper of the Law Commission, where it is noted that by no means necessary the case that non-consensual intercourse between spouses have less serious consequences for a woman, or is physically less damaging or disturbing for her than in the case of non-consensual intercourse with a stranger. The Commission also suggested that marital rape may be equally or even more grave or a serious offense when the conduct takes place between non-spouses, because it is rather the act that should have been the means of expressing his love for his wife. In its conclusive report, the Working Commission reiterated that, ultimately stating of that marital rape should be treated by the legal system in the same manner as rape occurring outside of the marriage. In making this assertion, the Commission acknowledged that several individuals concurred, emphasizing that one of the reasons marital rape is considered equally, if not more, grave than a stranger rape is because it involves the misuse of intimate act meant to convey love and is a betrayal of trust.
And don't forget the law under English jurisdiction regarding marital rape. The need for us to look into English cases is because although Section 375A of the Penal Code seems to cover marital rape, yet they did not have any Malaysian cases deal or invoke this section.
Thus, there's a need for us to refer to common law definition of marital rape and how English court have interpreted this matter over time. The main issue of marital rape is concern of wife, and the old presumption which was stated by Chief Justice Matthew Hill, as mentioned earlier, seems to just suggest that once a couple is married, there's a valid concern given for sexual intercourse. But can the consent be revoked? The later case of Our versus Clark challenged the old presumption and create an exception to the general principle by held Chief Justice. Although this case did not make the husband guilty for marital rape, the court given separate order for the couple, which implied the withdrawal of the wife's consent to marital intercourse. This case agreed that a valid marriage gives a husband access to his wife's body, but the wife's agreement to sexual relations with her husband can be revoked by another legal procedure, such as a court order. 20 years after Chief Justice held ruling, Our versus O'Brien established another exception to the rule. The wife's consent to marital relations was revoked according to the court because of a temporary divorce decision which make an absolute omission unless cause is proved to the contrary. The husband was accused for marital rape. The landmark case of Our versus Our challenged the landscape completely. Husband in this case was convicted for attempted raping his wife. The old concept of irrevocable consent of a wife to her husband was terrible. The relationship between the parties to the rape doesn't matter. Rape is rape. Accused for marital rape should be charged under Section 1 of Sexual Offences Act 2003, as the concept of wife's consent is irrevocable is not a good law. English case has gone through a lot to challenge and strike down marital rape exemption. Marital rape has been criminalized and treated similarly to non-marital rape under Sexual Offences laws. UK law criminalized non-consensual sexual acts within marriage, as we can see in Section 1B of Sexual Offences Act 2003. Consent plays a crucial role in proving rape.
English law did not codify a new law to specifically address the problem of marital rape. However, they treated marital rape as a form of rape under the law. English law treated marital rape the same as rape. Then, in order to prove marital rape, the elements are exactly the same as proving rape. Rape is defined under Section 1 of the Sexual Offences Act 2003. These offences can be broken down into 4 elements. First, penetration with the defendant's penis, of the complainant's vagina, anus, or mouth. Second, the complainant did not consent. Third, the penetration was intentional. And the fourth is, the defendant did not reasonably believe that the complainant consented. Now, there are 2 key about the crime of rape. Firstly, penetration. Second is consent. First key, penetration. Under Section 79, Clause 2 of the interpretation of the term penetration has also been made clear by stating it does not only apply to the initial penetration but is a continuing act from entry to withdrawal. In the case of Kaitamaki, rape is a continuing offense, meaning consent would need to be required from the beginning of sexual intercourse throughout. If consent were to be withdrawn during sexual intercourse, the man would have to withdraw immediately. Now, we are going to talk about the second key, which is consent. Sections 75 and 76 address certain presumptions as to consent and will be considered. Section 74 of the SOA provides that a person consents if he agrees by choice and has the freedom and capacity to make that choice. A valid given consent requires a complainant to be able to freely make the choice as to whether they consent to the penetration. In order to be able to do so, the complainant cannot be subject to any kind of pressure relevant to their actions. Whilst this point appears to be a question of law, the level of undue pressure that is sufficient to vitiate consent is a matter for the jury.
Determining a marital rape, actor-share and man-share still remains the crucial element. A leading case for actor-share, Crown against Kerr. Kerr clearly demonstrates the complexity in respect of the nature of consent. The complainant was a vulnerable and destitute 14-year-old girl who had sexual intercourse with the defendant in return for money that she could use to buy food. The Court of Appeal upheld the defendant's rape conviction despite there not being any obvious pressure placed on the complainant to consent. This judgment clearly demonstrates that undue pressure may take any form. The fact that the complainant believed that she had little choice because of her circumstances to submit to the sexual intercourse was sufficient to demonstrate that she could not choose freely and therefore did not consent. Moving on to the men's sphere, one very important thing to remember is that intention to penetrate. The act of penetration is a deliberate or voluntary one. In the case of Crown against Hurt, it will clearly be difficult for defendants to suggest that penetration was accidental. In the case of Crown against F, it was held that the trial judge was not at fault when stating in summing up the view that it was unlikely that a man might be able to penetrate while unconscious, retain an erection and ejaculate without waking up. It also seems that it is not a defense to state that the intention was to penetrate one orifice and another was penetrated accidentally.
In conclusion, the issue of marital rape in Malaysia is a complex and contentious one. The existing legal framework in Malaysia, as represented by Section 375A of the Penal Code, does not effectively address the problem of marital rape. While this section does penalize husbands who use intimidation or violence to solicit sex from their wives, it fails to explicitly consider the crucial element of consent. The omission leaves a significant gap in the protection of married women's bodily autonomy. Furthermore, there's a notable difference between the penalties for rape under Section 376 and marital rape under Section 375 of Malaysia's legal Penal Code. The injustice demonstrates how inadequate the existing legal framework is to deal with marital rape, as well as a distinct and a serious offence. It is beneficial to look at England's legal approach. The outdated idea that a woman's agreement to having sex with her husband is irrevocable following marriage has been rejected by English law as it has developed. English courts have affirmed that rape is rape regardless of the relationship between the parties involved. The landmark case of RVR in 1992 in England marked a significant shift as stated previously. Malaysia should seriously consider codifying marital rape as a distinct offence in the legal system. So, our three aspects for reform is: first, I would like to abolish the exception under Section 375. Second, allow marital rape into Section 375 as the elements to prove marital rape is same as rape. Third, leave Section 375A as a standalone provision as it is for crime which leads up to sexual intercourse which uses criminal intimidation. So by codifying marital rape, it is to benefit of protecting human rights. Protection of human rights as it recognizes the basic human rights to bodily autonomy, ensuring that individuals, particularly women, are protected from sexual violences within marriage. It upholds the principle that consent is necessary in all intimate relationships. It also serves as a deterrence. Legal consequences act as a deterrence, discouraging potential perpetrators from committing marital rape. Knowing that there are severe penalties for such actions can prevent instances of abuse and protect vulnerable individuals. By codifying marital rape as a criminal offence with appropriate penalties, Malaysia will take a significant step towards addressing a long-standing gender inequality issue. It will send a clear message that no one should be subjected to sexual violence even within the confines of marriage.
Ultimately, recognizing marital rape as a crime is a crucial step towards ensuring the rights and dignity of individuals, regardless of their marital status.
If you've made it this far, that means you've watched the whole presentation, and we thank you for that. Any last words, guys?
Thank you.
Thank you.
Well, that's all from us. Thank you very much.